would need to be an approved expense though.
Right.
All right. Good morning. This is Justice Oversight Committee meeting. And our first of the new session. So our first order of business is to elect a new chair and vice chair. And we have a clerk.
Our clerk is Peggy.
All right. Do we have, is Bryn here or a member of the Legislative Council? Usually operates the meeting until we elect a chair.
I'm here.
Oh, good, Bryn. Good morning, Bryn.
Good morning.
Would you take over till we elect a chair?
I sure
Please.
will. Yep. So good morning, committee. For the record, Bryn Hare from Legislative Council. And since it's a new biennium, you do need to elect a new chair and vice chair. And according to statute, you are supposed to also have a clerk that you elect from your membership. So if you'd like to do that as well.
I guess we're supposed to.
So we can do that as well. So it looks like you do have a quorum, so we can go ahead and get started. So the first item on the agenda is to elect the chair and the vice chair. So is there a motion to elect a chair from your membership? Yes, Representative Shaw.
Thank you, Bryn. I'd like to nominate Representative Emmons to be chair of the Joint Justice Oversight Committee for the next 2 years.
Okay, Representative Shaw has nominated Representative Emmons. Is there a second?
I'll second that.
Okay, and so if there's is there any discussion, or shall we go ahead and take a vote? Okay, so all those in favor of electing Representative Emmons as chair, please say aye.
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 Aye. All those opposed, say nay. So the motion passes and Representative Emmons is now the chair of the Justice Oversight Committee, and I shall turn it over to her.
Thank you, Bryn, and thank you, committee members, for your support. I appreciate it. Or your condolences, one or the other, for the amount of work. So as we continue setting up our committee structure, I would entertain a motion for our vice chair, which is usually a member from the other body. Senator Baruch.
I would move that Senator Sears be made vice chair.
It's been moved that Senator Sears be our vice chair. Is there a second to that motion?
And
Senator Lyons has seconded. Any further discussion? If not, all those in favor, please signify by saying aye.
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 Those opposed? Welcome, Dick.
Thank you. Thank you for the support.
So now we need to elect a clerk. I would entertain a motion for a nomination for clerk. Don't all raise your hand at once to see who would like to be clerk. Representative Wood.
Madam Chair, I would nominate Representative Shaw for clerk.
I
Since he
second the
doesn't- Since he
motion.
doesn't have to do anything.
Oh, he does.
Thank you, Teresa.
Former committee member.
I thought the clerk kept all the minutes.
Yeah.
Yeah. Remember having a clerk, but it's been moved that Representative Shaw be clerk. Is there a second?
I'll second that.
Thank you, Senator Sears. Any other nominations? Any other questions? All those in favor, please signify by saying aye.
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 Welcome. All those opposed? No. Welcome, Representative Shaw, to be our clerk. So we're going to get started with Bryn here, just walking through maybe some of our charges this year. Sometimes that's spread out between different bills, the appropriations bills, sometimes bills that come out of the Senate committees, and sometimes bills that come out of the institutions committees, or even some of the other committees like healthcare, human services, health and welfare, those type of things. Before we get started, though, I'd like to welcome, we have 3 new members to our committee this year. Senator Corey Parent, who serves on the Senate Institutions Committee. That's one I'm aware of, Corey, so welcome.
Thanks, and Ag.
And Ag. Representative Trevor Squirrel, who is now on the House Appropriations Committee and does have in his purview DOC issues as well as judiciary issues. And also Representative Teresa Wood, who's on Human Services Committee. And you're Vice Chair of Human Services Committee, correct? And also Teresa, her first year, she did serve on the House Institutions Committee. So there is some background there. So I'd like to welcome you folks aboard, and we're going to have a full schedule between the summer and fall. We usually have 6 meetings that we do between now and the end of December. And one thing that we like to do is try to set up our meetings as far in advance as possible, usually at least 2 months in advance, so that people can schedule either around our meetings, or if you have other meetings or vacation time, you can plan accordingly when you do the doodle poll for our meetings for that. So any questions at all from members or anything from the new members for folks? Okay, so Bryn,
Alice, I did have a question.
Yeah.
When we do the doodle poll, will we be looking at meetings face to face, or will we be looking at Zoom meetings? Do we know yet?
We don't know yet. I think the intention was that 30 days after the governor lifts all the restrictions, it'd be 30 days after the summer study committees, joint committees could meet in person at the State House. And the thinking would be that that might be the first part of August and after. What is happening now is, as you well know, the governor is waiting for the 80% for folks, Vermonters, to be vaccinated. That will then lift all the restrictions. So how does that impact what we do in the State House? I don't think anyone is really clear at this point. I know that Janet Miller told me that Kevin Moore has ordered the cameras because they really want to make sure we can continue doing some form of Zoom or YouTube streaming live from committee rooms or from room 11, room 9, wherever summer study committees will be meeting. So they want to get that set up first. So I don't know what the time frame will be, but I would anticipate probably by August, our August meeting would be in person. July, I don't know. I would like to be in person. I really would. I know it means getting up earlier and driving north, but so does anyone know anything different from what I've just said, Dick?
Anything different from what you said? I think we should, if we do a July meeting, I think we should plan to have that remote and then try to do our August meeting in person. If everything the governor has talked about in terms of their loosening the restrictions, and if Ledge Council is ready and the IT folks are ready for us. So I think August or September would be probably the first day live. But I'm hopeful also there'll be the opportunity to continue to have a YouTube or some kind of Zoom option for witnesses and others who can't make it to Montpelier. One of the things that I found for people from Bennington County is a tremendous help to not have to drive 2.5 hours to testify on a bill for 15 minutes and then drive back to Bennington. So I just think we should be cognizant of the benefit that we've had from Zoom meetings and the benefit to the constituents. And also, I must say to the public who are able to watch our proceedings rather than squeezing into a tiny committee room.
And I think that's the direction that the General Assembly will be. And that's what Kevin Moore and our IT folks are working on. Because there'd be different cameras than what are normally used, so that they can get different angled shots. And that's what Kevin is working on. And then you've got to set all that up in whatever rooms we're going to be meeting in. So there's some logistics involved. So August is probably the time frame for us. Anything else before we turn it over to Bryn? Okay, Bryn, welcome again.
Thank you.
Just introduce yourself for the record and then give us our charge of what we need to do for the next few months.
Will do. Okay, so again, good morning, Bryn Hare from Legislative Council. So typically what I do at the beginning of the off session for this committee is to run through the different legislative charges that you have as were passed during the previous legislative session. So I have a presentation that I'm going to go through. It's not going to be very long. I'm not going to do a summary of all of the bills that I'm going to be talking about. I'm just going to hone in on those sections of the bills that have some sort of legislative charge for the committee. Most of those charges are going to be reports that you need to hear from various stakeholders. There are, this year you do have a couple of sort of broad charges to look into a particular area or policy and deliver some recommendations either to the standing committees or in the form of legislation. So I'm going to start with those. So I'm going to share my screen and you'll let me know if everybody can see what I have here. And I'm going to, let's see, start a slideshow.
And Bryn, you can submit this to Peggy so it can be posted on our webpage.
It already is.
Okay.
Yep.
Thank you.
Okay, so can everybody see that? Okay.
Mm-hmm.
Okay. So again, I'm just going to run through this pretty quickly. I'm aware you have a full agenda today, so I'm not going to take a whole lot of time, but I did want to start for the new committee members just to point out what your legislative charge is, sort of your overarching duties by statute. And those are to oversee the Department of Corrections, and that includes evaluating their strategic, operating, and capital plans for the Department of Corrections, overseeing departmental policy, and encouraging communication between the department and the administrative branch in the criminal justice system. And also, you're charged with sort of this broad scope of duties here, overseeing the statewide juvenile and criminal justice system. And that includes evaluating the statewide system of pretrial services, diversion programs, community justice center services, and evaluating the consistency and cost efficiency of the justice system, ensuring the statutes reflect principles of restorative justice, and also reviewing the timeliness of judicial proceedings. So that's your broad sort of overarching legislative mandate. And then now I'm going to jump into the bills that were passed this session that have specific directives for this committee. So I'm going to start with the big bill 439, the Appropriations Bill. So this is one of those broad mandates for the committee that directs this committee to examine something and then deliver a report. So this is directing the committee to examine the current system for transporting prisoners and people with a mental health condition or a psychiatric disability who are in the custody of the state. It's specifically including those transports that are provided by deputy sheriffs who are paid by the state, and transports that are provided pursuant to contracts with state agencies and sheriff's departments. So this committee is tasked with recommending changes to that existing system and identifying any benefits and consequences related to those changes. And it also specifically requires that though any recommended changes that are put forward by this committee have to comply with human services policies on the use of restraints. So the directive here is to look into this, examine it, and then deliver a report to the standing committees on November 15th, on or before November 15th of this year. So that's work that probably needs to take place earlier rather than later in the interim. And then there's language down here in subdivision C here that requires the committee to review audits that have been prepared by the state auditor regarding the use of deputies who are paid by the state during a declared state of emergency. So some specific directives there for the committee. Again, this might be something you want to start planning for in the summer. As the chair mentioned, you do have 6 meetings that are authorized by statute. And if you want to have more, you do need to get permission to have more meetings. So I'm going to move on unless somebody jumps in with a question. The next big directive that you have is set out in S7. This was a bill that ended somewhere very different than it started. It's an act relating to sealing and expungement of criminal history records. And the legislature did quite a bit of work on this bill, but wound up, instead of changing the policy for how the state seals and expunges criminal history records, it directed this committee, the Legislative Oversight Committee, Justice Oversight Committee, to kind of conduct a wholesale review of how the state does sealing and expungement of these records, and come up with a more streamlined, simplified process for how the state does this. So specifically, you're directed to consider how to simplify and automate the process of expungement and sealing, and also consider a comprehensive policy that provides a method of expungement for all or most criminal offenses, except for those that are considered the Big 12 offenses, which is sort of the 12 most serious criminal offenses. And also you're directed to consider whether to exclude from eligibility offenses that are associated with or stemming from domestic abuse or sexual violence. And then you're also directed to consider a policy to determine what individuals or entities should have access to sealed records, whether Vermont should continue to have kind of a 2-track process, which is sealing and expungement. Some records are eligible for sealing, some are eligible for expungement, some are eligible for both. Whether you should continue with that policy or if you should provide just one or the other, sealing, all eligible for sealing, all eligible for expungement. And also you're supposed to consider how to implement an automated process or a petitionless process to seal or expunge records that would provide for a notice to the prosecuting office and an opportunity for that prosecutor to oppose sealing or expungement. And I suspect that some of you are much more familiar with this with the existing policy than others. So it may be helpful to have kind of an overview of what the system is now. I will note just briefly that now there's a limited set of crimes that are eligible for sealing or expungement. So this directive is really to have the committee take a look at a policy that would allow for most, all or most criminal offenses to be eligible for either sealing or expungement. So I don't know how much you want to talk about this now.
I would hold off a little bit, Bryn. I think this would be, you were reading my thoughts because we do have some new folks on the committee. We also have folks that haven't lived this past session and prior, and it would be good to do a review of what's currently in place. And I would suggest we put that on the agenda for our next meeting for that.
Okay.
Is there any questions on this or the one previous to?
Yes, I actually have a comment on this or a question. It's important to note that this study, the Sentencing Commission actually did a study that recommended much of what was in S7 when it passed the Senate. And as the House began to work on S7, the administration had difficulties with it. So this is why the study is here. I think it's we should ask the administration to come in and explain its position, given their concerns about the process that they expressed. Some of it, I give great credit to Representative Grad and the members of the House Judiciary Committee for working their way through that. But it was after the bill had passed the Senate. And it was basically the recommendations of the Sentencing Commission. So perhaps we should have the chair of the Sentencing Commission also at our next meeting to explain their view of this, because it took many of us by surprise. And the House Judiciary Committee did a fantastic job of at least getting a bill through with and includes this study.
So that's very helpful. I was in the loop on some of those emails that were sent by the administration on this. So I would defer to both Senator Sears and Representative Grad to help us with Peggy to figure out who to invite for our next meeting on this. And
Can I ask a quick question?
Ginny?
Because I didn't sit through all of the discussion on this, but I'm looking in particular at number 3 under Sec 5 of S7, and or actually all of it. Was there any judicial discretion? So is the judiciary and was at any point there discussion about having the judiciary involved in just making a determination about whether or not to seal or expunge?
Are you asking that of both judiciary committees?
Yes, I am. Thank you.
So
On the Senate side, I think it's fair to say that Judge Grierson was supportive of sealing. He sees that as a better way to do it.
Okay,
As long as
thank
it
you.
has the same impact as expungement.
Yeah, thank you.
I don't know if you heard anything different on the House side.
Maxine?
Thank you. No, we did not hear anything different. And but to answer your question, yes, sir, there certainly was consideration.
So if both the chairs of judiciary could work with Peggy so that we can line up the folks to testify at our next meeting, that would be helpful. Any questions on the previous one about the transport of prisoners or folks with mental conditions or psychiatric disability? Any questions on that one? Okay.
Okay, so I'm going to keep going then. So the next one, we're back to the Appropriations Bill. This was a directive to the Department of Corrections regarding correctional officers and body-worn cameras. So there was language in the big bill that provided that DOC shouldn't deploy any body-worn cameras until it adopts a policy on their use. And then it has some specific directives for the department about developing that policy and the stakeholders that it should consult with in its development of a body camera policy. And it requires that DOC report to this committee with a progress report, kind of an update on its development of the policy by September 15th. And specifically, that report also needs to include an identification of the ongoing cost and funding source for the use of those cameras. And that funding source should include training, data storage, redaction, and similar considerations. when it reports to this committee. And they're also tasked with reporting to the Joint Fiscal Committee with that information. So progress report on correctional officer body worn cameras is coming to you in mid-September.
And if I recollect correctly on the language, this tracks language that was adopted on other policies for body cameras to be used within our state police, I believe. We tried to track, because this language came from the House Institutions Committee. We tried to track the language that was already in place for other entities that use body cameras. And we worked with Trevor Squirrel on this, Representative Squirrel, to be included in the Appropriations Bill. Any questions? So this one, Bryn, is just a report back to us in September. Just sort of a check-in.
Correct. Okay.
Alice, I have a question.
Yeah, Cheryl?
So the report is due in September. What was the ultimate date for implementation? Or was there?
Well, there's another report due to the Appropriations
February.
in February. So that that would be probably the trigger in terms of implementation with money.
Was there any indication?
Was there any money, Trevor, in there in the Appropriations Bill for purchasing? I'm trying to remember. There was at one point, then it was taken out.
Well, the money for appropriation, for body cameras for DOC was $1 million.
And that stayed in, right?
It did stay in, yes.
So the thinking was that it could not be expended until the policy is put in place. And then the report would be a check-in for us halfway through. And then February 15th, it would then be the policy, the thinking would be in place. And then that needs to be presented to the two appropriations committees.
My question was there a target date for implementation so that, the policy would, I'd see that the policy is expected in February. When does the implementation occur? But that may not have been included in the budget.
I think, so the language has a specific requirement that the policy be developed by January 15th and the department report to the standing committees, the GovOps committees, and the House Corrections and Institutions Committee, and the Senate Committee on Judiciary is going to hear their policy at the beginning of the next legislative session. So I think the idea was check in with what they have developed as a policy at the beginning of the session, and then by February to report on the status of their deployment.
Okay, thank you.
Other questions? Okay, let's move on, Bryn.
Okay, so we're still with the big bill. This is another issue that you are going to receive a report on. So this directs the JFO to prepare an issue brief to present to this committee on criminal justice fines, fees, penalties, and surcharges. And that brief needs to specifically provide details about the revenue generated by these fees, surcharges, fines over the last 5 fiscal years, and the projected revenue for the next 5 fiscal years that come from these fees and fines. Also, an inventory of the programs that are supported by the revenue that is generated by the fees and fines and surcharges, and also the projected funding needs of those programs over the next 5 years. And additionally, the JFO report is directed to provide options for alternative funding sources for those programs. Directs JFO to consult with program stakeholders and have the assistance of the executive branch in providing the issue brief to this committee. And they are directed to provide that to you in either November or December. So you can expect that a little bit later in the interim. Any questions about that?
I don't see any, so let's move on, Bryn.
Okay. So now we're moving on to a different bill. This is H435. This was an act relating to miscellaneous Department of Corrections related amendments. And this is a directive to the Criminal Justice Council and the Department of Corrections to develop a proposal regarding minimum training standards for correctional officers. Also, complaint investigations and a process for certification and decertification of those officers. So this report is scheduled to come to you on December 1st. And it's really a proposal for how correctional officers should receive minimum, if there should be minimum training standards for them, what a complaint investigation process would look like, and who should be responsible for certification and decertification of these officers. Also, the report is required to include a fiscal and programmatic impact of the proposal. So that is scheduled to come to you in December.
Questions? Okay. Let's continue.
Okay, next is Act 24. This is the one that has an act number. And this was an act relating to earned discharge from probation. And this section directs the Sentencing Commission to issue a report to this committee. So this one is pretty narrow in scope. The Sentencing Commission is tasked with looking at the existing statutes regarding misdemeanor probation terms, and also a report that was issued in 2020 from the Pew Charitable Trust on whether states can shorten the terms of probation for misdemeanors and also protect public safety. And they are specifically tasked with considering whether Vermont should limit the duration of probation terms for misdemeanors to 2 years. And so that's going to be a pretty narrow in scope report that you receive from the Sentencing Commission. And you'll hear that on or before October 1st.
Any questions? Okay, let's continue, Bryn.
Okay. So the remaining reports that you're scheduled to hear from legislation that was passed during this session is going to come during the next legislative interim. So there's 3 of those. I put them at the back of this presentation. Thought you could just have a little heads up about what's going to come later on next year. So again, this is the Earned Discharge from Probation Bill. This section requires that the department collect information about its midpoint review process. And without getting into details about the bill essentially set up a process that both the court and the department need to follow when considering whether to discharge people from probation at the midpoint of their probation term. So the bill directed the department to collect information about it, including the number of probation discharges or term reductions that were sought by the department, and the number of probation terms that were actually reduced pursuant to the act, and the amount of time that were reduced from probation terms as a result of motions that were granted by the court. So this section also directs that as a result of that data collection, the department has to report to this committee starting in August of next year, and then again in August of the following year on that data and recommendations for any further changes to the midpoint review process, sort of as a check-in to see how this new midpoint review process is going, and to give this committee some specific weigh-in on what the data is showing about midpoint reviews.
Questions?
So again, that's not this year.
I
That's next year.
have a request. And if Peggy or Bryn, if this document could be mailed, hard copy to everybody on the committee, it would be helpful to keep in mind, because I lose track of where documents are when I don't have hard copies. And it would be helpful, at least to me, and I suspect other members, to know this is sort of like what are our obligations beyond the normal things that Justice Oversight is responsible for.
That would be very helpful if we could do that, Peggy. It would save on some printing costs for some of us.
Yep, no problem. I'll have that sent out to you guys.
Okay,
Thank you.
thank you.
Okay, so I'm gonna keep going. There's just a couple more.
Okay,
Back to the big bill. This is another report that you're going to receive not until next year, so September of 2022. This is funds. This is a report you're going to receive on unexpended funds for correctional services for out-of-state beds. Oops, sorry. Where did I go? There we go. So this is a report from the Secretary of Administration on any unexpended funds for correctional services that are carried forward to fiscal year 2023. And you're going to hear a report about the amount in September of 2022. So don't have to worry about that this year. And then lastly, one more report that you're going to hear next year in 2022. This comes from the S3, which was an act relating to competency to stand trial and insanity as a defense. And this one, the Department of Mental Health is going to report to this committee by August of 2022 on whether or not a forensic treatment facility is needed in the state. So again, that is a report that you're going to hear next year. That's work that will be done by a working group during this next year, and you'll hear a report next summer. So that is all. Here's a little summary slide of what you have. Oh, I see a question, so I'll hold off.
I'm sorry, I was looking somewhere.
Yeah, no, it's a quick question that this, the forensic unit, there's nothing in this report that requires the report to be in place before planning goes ahead with any mental health forensic unit. There's nothing here that says the treatment facility discussion can't go forward without this report.
Right, that's correct. And also I would just note that there's a preliminary report that comes to the standing committees in January, this coming January of 2022. And the report that this committee will receive in August of next year is supposed to be a final report from that working group.
Thank you.
Okay, so lastly, this is just an overview of your schedule. First couple of things are your, apart from your legislative mandate, the first couple of things are the policy issues that you're tasked with delving into to deliver some recommendations. So remember that comprehensive expungement ceiling policy that you're tasked with coming up with. Then you're supposed to examine that system of transports and deliver a report in November to the standing committees about transports, your recommendations for how to change the current system of transports. September, you're going to hear the progress report from the Department of Corrections on its development of a policy on body-worn cameras. October, you're going to hear from the Sentencing Commission on that narrow issue about whether Vermont should limit its probation terms for misdemeanors to 2 years. November 15th is when you're supposed to provide your report to the standing committees on transports. And then in either November or December, you'll hear the issue brief on the judicial fees and fines from the Joint Fiscal Office. And then December 1st, you'll hear the proposal from the Department of Corrections and the Criminal Justice Council on how correctional officers should be trained, certified, decertified. And then finally, I just noted that in December is when you'll need to start thinking about your recommendations for proposed legislation on the expungement and sealing issue, and then on any other issue that you hear testimony on during the off session.
That's great. Thank you, Bryn.
Sure.
One thing, we do have time scheduled later on today to talk about our future meetings and future agenda items. So we do have some specific charges here that Bryn went through. And then we're receiving reports on some other issues that it might be good to receive background information on that before we receive the reports, is one thought. And then other issues that folks are interested in exploring as well. So we can have that conversation before we finish up our work today for our future agendas, if that makes sense to folks. Okay, anything else before we transition to S107, which is the dealing with confidential information regarding the arrest and charge of a juvenile. Any further discussion on
I'd like to make a comment about S107.
Yes, I was going to recommend that both you, Senator Sears, and Representative Grad lead this part of our agenda, because there was a lot of work done in both of your committees with this. So I'll turn it over to you, Dick.
Well, S107 actually came out of the Senate Government Operations Committee, not the Senate Judiciary Committee. But what I was taken back by was the content of the governor's veto message. And any of us could have a disagreement about the public's right to know about certain criminal activity and certain actions. And I think that was the issue that S107 tried to deal with. And I quite frankly have, while I supported S107 and the way it was drafted, I can understand why there'd be a difference of opinion. And that certainly is the governor's prerogative. What upset me about the governor's veto message was the references to raise the age. There is a 2019 report that was done that came out of both the Senate and House Judiciary Committees when we approved raising the age. That report describes exactly the process that the state needs to go through in order to be successful and raise the age. We did this in stages. We waited until July 1, 2020 before we raised the age to 18. We waited until July 1, 2022 before we raised the age to 19. So we've taken steps to go slowly. This was a 2019 report. And if you look at the report, I think that the administration, frankly, has failed to live up to what was in the report. And so that's what troubles me. To suggest that raise the age is a problem when we don't have the resources available. And part of that is the failure to establish an alternative to the Woodside program. At this point, we're still flailing in that direction. We're hopeful that something will be coming forward. But it's with that, and with all due respect to the administration, if you look at the report, I'd like an update of exactly where the administration is, where the state's attorneys are, where the judiciary is, and all the others in terms of raise the age. And I did have a good conversation with Commissioner Brown yesterday, and I was happy to hear that the commissioner is committed to continuing to raise the age. But reading the governor's veto message on 107 would lead one to think that raise the age has been a failure. I don't know how something can be a failure when it's not even been fully implemented. There are some problems. I think those problems are with the lack of resources, and I think those problems are with some difference of opinion in the various state attorney's offices. As we know, there's 14 of them, and sometimes 14 different state attorneys are 14 different forms of justice. So I'll stop there, but those are my concerns with this, and I'm really glad that this is on the agenda today, and perhaps we can clear the air.
Thank you, Dick. Any comments before we?
I don't know, Maxine may also have, because we work closely together on this.
Do you want to weigh in, Maxine?
Sure, just briefly, and our committee did not look at this bill because it really, as Senator Sear said, was a public records issue. But I do very much appreciate this being on the agenda today. I think there is a lot of perhaps confusion about what raise the age is. I think there may be confusion about raise the age and youthful offender and possibly mixing the two. And so I very much appreciate the testimony and hope that we will really understand what raise the age is, all the work that went into it, and the enormous support that was given, including by the administration, and how raise the age and emerging adults is very much based on data, and which is so important for us to be having data-driven policies. So with that, I thank you. And actually I do, if it's okay, want to recognize Representative Hal Pilstein, who is was a member of House Government Operations and was the reporter of S-107. So I did reach out to him because I think it'd be helpful for him to be here and for us to have him with us. So thank you.
Great, thank you. And thank you, Hal, for joining us. I appreciate it. And when we get into the question pieces, Hal, if you have any questions or comments you'd like to make, please feel free to do so. That'd be great.
Thank you.
So with laying the foundation for the discussion, I'm now going to turn it over to Commissioner Brown, Commissioner of Department of Children and Family Services. And Commissioner, welcome. You've also heard the concerns of some of the members, and if you could extrapolate that a little bit and engage in a conversation with us, that would be very helpful. So welcome, and if you could identify yourself for the record.
Thank you. Good morning. Sean Brown, Commissioner for the Vermont Department for Children and Families. And with me today from the department, I have Tyler Allen, who's the director of our Adolescent Services Unit. He is here to speak in a little bit more detail about the report that Senator Sears referenced that he'd like an update on, and the full committee would want to hear on as well. I do want to stress that the administration and the department are committed to raise the age, and the policy that we put forth as a state several years ago that first became implemented in July 1st of 2020 for 18-year-olds, and currently July 1st, 22 for 19-year-olds. When we move forward on this, we were the first state in the nation to move in this direction. So we're on the vanguard of this movement. I believe one other state, Connecticut, is close to implementing something similar to Vermont, but hasn't as of yet. And so when this initiative was moved forward legislatively, it is based on research, science, and data, and we will continue to move forward and implement it with our eyes on the research and the data and the science on how to best serve emerging adults. That said, we anticipated there would be a learning curve, given we were the first in the nation to move in this direction, and there's not a playbook that we can turn to or look to other states' experiences, and so we recognize that there would be bumps in the road, and I think we've seen some, and we have given our experience over the last year implementing this. And I'd also want to just stress that we cannot underestimate the impact that the pandemic has had on Vermont's system of care and our judiciary system. It's really stressed those systems and shut them down for periods of time. And it has created circumstances which have been hard to move forward and implement certain things that we'd like to do. But now that we've had the year of raise the age for 18-year-olds, we've certainly had some experience with it. We recognize some of the gaps in the system of care and the system in general, whether it be programmatic or bricks and mortar. And one of the things to remind the committee, as I came on board, just as raise the age took effect in this past July, quickly recognized that housing was a big issue for raise the age adults being referred into our system of care now. And that we, in the BAA and in the 22 budget, requested resources to develop some transitional supported housing type programs for raise the age and also youthful offender emerging adults that needed that type of service. We are moving forward to implement those programs where we have an agreement with a provider in Central Vermont and we actually have one youth in the emerging adult in that program now. We're also negotiating with a provider in Bennington to take over some programming and change some programming there in the Depot program. Also, we're going to be looking to create a similar type program in the northwest part of the state in the coming months as well, so that we will have coverage throughout the state for supported, housing support services and other, help them connect with job training or education, things that are emerging adults that haven't had the ability to focus on that as they developed, that they will have the time and the space to do that and a place to live while they do that. That was certainly a gap we identified early on. I think the other issue that we're grappling with is that many of our service providers that we currently use in our juvenile justice system that serve under 18-year-olds really haven't developed in a way to serve emerging adults that are 18 or 19. And so that's an area that we're going to need to focus on in the coming months in the year, is to make sure that we have other type of programmatic services like residential treatment outside of like psychiatric level, hospital level type care. Just doesn't exist for emerging adults. And that's an area we want to work with our providers and get some proposals going, because that's an area I think that we need to further develop and expand in the state to meet the needs of this population, emerging adults. We've also seen some unintended consequences of our work in this area, and we have been working with the juvenile justice stakeholder group to identify and problem solve. And it's our hope that, in the coming session that we'll have agreement and we'll come forward with some proposals how to modify the raise the age to improve it and enhance it. One of the areas that we're seeing some concern is how it overlaps with the youthful offender program in the state of Vermont. When prior to raise the age and the discussion and implementing it, youthful offender was used very little in the state. And at the time of the passage of this, there were approximately, on average, around 33 to 35 youthful offender petitions a year. This year, through the end of May, we have now had 530 youthful offender petitions filed, and we're on track to exceed 1,000. In 20, it was 390 petitions. So we are seeing an escalation of youthful offenders, and I don't think we anticipated seeing that. And also we're seeing a level of some areas, a level of dangerousness that's concerning in the youthful offender and raise the age, where we didn't expect to see youth with a level of dangerousness in our system of care. And one of the areas that we're working with the juvenile justice stakeholders is to improve or change a dangerousness assessment to see if that emerging adult or youthful offender is appropriate for our system of care versus the adult system of care. And then also we have seen the start of a concerning trend where emerging adults or juveniles from out of state are coming into Vermont and engaging in behaviors that are very problematic. And then it gets complicated with the interstate compact for juveniles and how we charge and then return those juveniles to their home state. has created some complexities as well that I think we need to think through. And so those are just some of the areas that we've identified that we want to focus on and we have concerns on as a department and administration. And I think just given our focus as a department on responding to the pandemic, as we transition out of our pandemic response and back more to normal operations, we look forward to being able to focus the time and energy on these issues that deserve our attention on this. And so we intend to continue to meet with the state's attorneys and the Defender General and the judiciary, to have these ongoing conversations and understand what the needs are, where the gaps are in their communities, so that we can make sure we come to you with a request to develop and build those services that our emerging adults need to be successful, currently and later in life.
So, Commissioner, I have a question on the youthful offenders and the trend that you're starting to see, where there's an increased number of requests coming in, but also the higher level of need and problematic behavior that you're seeing. Where are the folks being housed in the interim, and what services are being provided to them?
We do have a variety of providers in the state. If they're are under 18, they are being served in our residential system in state. Some of them are out of state. And then we have used our agreement with Sununu, particularly for youth that have been picked up in Vermont that are from other states and have been picked up for offenses here. Under the ICJ, we need to house them in a secure location. So we've had 6 youth that we've housed for various periods of time at the Sununu Center as we engaged in the legal ICJ process to return them to their home state while we resolve their proceedings in Vermont. And then some youth are if they're over 18 and charged as adults, some have been held pending bail, pending a youthful offender status. That's how that process works. And then if they are granted youthful offender status, then primarily they're served with community services, and many times it's a joint supervision effort, a probation effort between DOC and DCF, and that we work together to make sure that we're engaging and serving those emerging adults, depending on what their needs are.
So I know last fall, we worked with you on what was called the Beckett Proposal, which I'm assuming would have, if this was up and running, would be housing some of these youthful offenders or not?
It would not. That program, just as Woodside, was serving youth under 18.
Dick?
Yeah, a couple of questions, Commissioner. One is the age of those kids who were sent to Sununu from out of state. I believe the governor mentioned that. He didn't mention them obviously by name, but mentioned that out of state population. What were the ages? Were they under 18?
They were. To be placed at Sununu, they would need to be under 18.
Okay, and did they commit crimes that would be a Big 12 offense? Or were they charged with crimes that would be
They
Big
were
12?
charged with serious offenses.
Okay. Secondly, were the 1,000, or are you predicting 1,000 youthful offender filings? How many of those are actually accepted as youthful offenders by the courts after going through the whole process?
Yeah, I would need to get that data back to you. This is just the filings.
Judge Gerson's on this call, and so we would, as well as the state's attorney, so I'd really like to know. And I believe that you'll find that the defense bar feels they need to, in order to adequately represent their clients, ask for a youthful offender status, but they may not be successful with the courts and so forth. So just asking for youthful offender status doesn't mean they'll actually be. Am I correct in that?
That is correct, that there is a
So
judicial
it
process.
may be a much smaller number than that. Maybe there's something in the law that the Defender General feels they need to apply for youthful offender status.
I know that Hal has a question, but I want to make sure that members of the committee have had their
I'm-
questions
I'm
asked first.
Pretty well done, but I really want to focus on that out-of-state group because that was mentioned in the governor's message, and I think it's important to recognize that. I believe that that wasn't due to raise the age. Maybe it was.
Any other questions, comments, folks, before we go to Hal? Jenny?
Yeah, I'd like to go back to the Beckett question. I understand that it was meant to, the Beckett facility would replace Woodside, which is, but 18 and under. But if we concur with raise the age, then would that automatically allow for older kids to be at Beckett? So I'm just getting confused by the response that I'm hearing.
Senator, our agreement with Beckett right now is that their experience is working with under 18 and not older than that in general. And so our program with them will focus on under 18. Also, as a part of the approval from the legislature, we engaged in significant public outreach and several public forums with the community. And that was one of the areas that the community expressed concern about, is that there would be the ages of the individuals served in that facility. And there was a concern that it could turn into an adult facility. And so one of our agreements with the community is that it would serve under 18-year-olds at this time.
Okay, thank you. But it does sound like a chicken and egg question and situation. If we're going to move forward, then it sounds like it would take additional negotiation and work with any local community that would be hosting a facility like this. We're in a very difficult place right now. If we, as you said, Commissioner, you were very interested in moving forward, but for certain elements. And I think we're also interested in moving forward. The question about having housing appropriate facility is a big one. But if we move forward as we have in the past, I just question whether we'll ever get to where we're going. That's all. I know it's difficult for everyone.
Butch? Hal, I'm going to get to you. I just want to get the committee members first. Butch?
Sorry for jumping in, Hal. So I have a question for the Commissioner. When you were speaking about the demand for services and who is coming into the system, you kind of, I thought, bleeped over the out-of-state folks that are not bleeped over, but talked about out-of-state youth that are coming in and committing an offense. And but I didn't get a feel. I mean, we read that that's become a problem. How big a problem is that, and what type of offenses, if you can tell me, what type of offenses might these folks be in a possible resolution?
Yeah, they're mainly related to drug trafficking and weapons violations. Our concern is it's something that's just emerging. We've had 6 youth picked up under similar circumstances, primarily in southern Vermont, from neighboring states. And we're still trying to understand it. We're working with public safety to understand it, if this is connected to some sort of organized effort by out-of-state traffickers recognizing the ability to send emerging adults or under 18 into the state, recognizing our how we've structured our justice process for youth and emerging adults. And so this is something that's new, and we're trying to understand it ourselves and research it a little bit more.
So did I hear you say something about you're working with their home state once you get to a resolution point, or maybe even a detention point or whatever? And do these youth go back to their home state for those services, or do we handle them in Vermont?
Yes. So there's a process. There's a federal compact called the Interstate Compact for juveniles, and it kind of provides a framework for states, for youth on the run or who get in trouble in other states, and how the process works, where you are able to return those youth to their home state or to another state for services or treatment. And we make a request, and states have so long to return or accept their youth, and then based on the status of their charges, some can hold off on that. And so it's a very complicated law to begin with, and then it's complicated more by the circumstances of these youth and their age. Many of them are close to age 18. And so we start bumping up into, that we can hold them up until 18 at Sununu, but at that point, they can age out of the system of the juvenile system if they're treated as a juvenile. And so there's a lot of complexities here. And we're still, given the newness of this, we're trying to understand it. And develop protocols and processes around it, give it something we're just starting to experience.
Thank you, Commissioner. Thank you, Madam Chair.
Any other questions from the committee? Hal?
Thank you, Madam Chair. And thank you, Commissioner Brown. I have a question. You talked about the significant increase in youth offenders. And my question is, how do the numbers break down racially? And are they in line with our census data?
I will say youthful offender can serve, you're eligible to be deemed categorized as a youthful offender up through age 21, just to provide that framework to the committee. And I will say, I don't have specific data on that for youthful offender, but I will say one of my concerns, Representative Colston, when I came on board as commissioner, when Woodside was open, was the disproportionate number of youth of the BIPOC community that were in Woodside. And I think that's probably, I don't want to speculate, but I think that's probably representative of our broader data. If we looked at our data, that might be more representative of what we'd see in our systems right now, in terms of proportion.
Thank you.
Any other questions of the commissioner before we move on? I'd like to go next to Judge Grierson. But any other question of the commissioner? So I do have one. Is there any thought on a relief valve at all for housing some of our youthful offenders at all, to take the pressure off of DCF and some of your caseworkers? Has there been any thoughts on that at all, Commissioner?
In terms of?
Just trying to find maybe some state-operated, state-owned arena that possibly could help in the interim before, to help things settle down before we really know where we're going long-term. You
Yeah,
got
I
any
think that
questions?
that's the work we're doing now for some of, for the resources that we got through the budget process this past session, are to create some housing services and opportunities for emerging adults and raise the age population, because they really did not exist right now. They existed in the correction side of the world, but they didn't exist in the DCF system for that age population. And we quickly identified that as a gap last summer and asked for the resources. And so those programs are getting up and running now. And so we hope that will provide some relief, not only for where we might be able to place someone for, for our caseworkers working with these youth, but also as judges are handling those cases as well. We want to make sure that if someone's picked up and they don't have a place to go, and we really don't want to hold them in any type of other type of facility, that we'll be able to access some of these housing services pretty quickly for these youth before we start the adjudication process down their case, down the path of adjudication for these youthful offenders. Because that was some of the circumstances that led us quickly, is there was a couple cases where the court was struggling what to do with a raise the age youth, given they were homeless. And so that was the impetus, is really trying to move quickly to get some resources to build these services for this population in the DCF system of care.
So I guess I'm just focused on that interim piece, because the youthful offender person needs to be housed somewhere, because it's going to take time to establish those programs with the private entities, correct?
Well, we are actually using one of those programs now, and many of these are existing programs that we're going to convert to DCF systems programs, and so they're already existing operating programs that we're already using one of them, and we have the resources in place now to contract with those providers, which is what we're doing. And so we're starting to use those resources now. And I would say this is only for a subset of the population we serve, or raise the age or youthful offender. Many of them have support systems in place already, or are committed a level of offense that's minor, and so they don't need a greater level of supervision. We just need to make sure that they're staying connected with their system, their support systems, whether it's a family member or a friend or their own living arrangement that they've already have, that we just need to make sure they're staying connected with that, and that we're connecting them to services, and that they're staying engaged to services in the community, whether it's mental health treatment, substance abuse treatment, employment related, education related. And so this is just for a small subset of the population that we're experiencing.
Okay. I mean, I'm just concerned that sometimes they just may need to be housed somewhere with your staff, not in a hotel room or anything, but some other placement. And there may be some opportunities in some state-owned facilities that we currently have vacant that might be able to be used in the interim for that. I don't know, just a thought.
Yep.
For that. Any other questions before we shift over to the judge? Okay, Judge Grierson, welcome. And I think you've heard some of the questions that have been asked or concerns, and maybe we can start with the question of how many of those filings for youthful offenders are actually approved. If you have any insight into that, and then we can do a deeper dive. So welcome. And
Good morning.
identify
Good morning,
yourself.
Madam Chair, and thank you for inviting me to appear before the committee. For the record, Brian Grierson, Chief Superior Judge. I did, and I'm sure you haven't had a chance to review it, but I did forward data late yesterday afternoon relating to this current fiscal year up through yesterday, up through June 2nd. data relating to not only CHIN's filings, but delinquencies and youthful offender. And as the commissioner said, the youthful offender filings are up. As I heard that question, both from Senator Sears and the commissioner's comment, I did reach out to our tech staff to find out if the numbers that the commissioner referred to and the numbers you'll see on the data I provided, were they initial filings or were they cases actually accepted for youthful offender status? And as it turns out, the quick response I got is consistent with what Senator Sears was saying, and that is those numbers that I've provided to you are the number of youthful offender filings. It does not represent those accepted by the court for youthful offender status. And I will try to get that data for the committee for future hearings, but I do not have that today. Listening to some of the questions and the testimony of the commissioner, I would say to this committee that based on results I received from judges who have been sitting in the juvenile division since July last year, since the raise the age went into effect, I think the almost universal response has been that and I think the numbers that I provided to you bear out that we have not seen a significant rise certainly in delinquency filings as a result of raise the age. I think the concern as we started down this path a few years ago that it would lead to significant filings and the concern, of course, on the part of the court was with an already congested docket, what that would mean. We have not seen, as I said, a significant increase in filings. Now, to what extent that may be attributable in part to the pandemic year is hard to gauge, but those cases that have come in, for the most part, we've been able to see those resolved to a great extent through diversion or restorative justice programs. And I would have to say from the judiciary's perspective, that certainly the initial phase, if you will, of raising the age to 18 has gone well. The concern that I hear from the judges has been touched on by the commissioner, and that is this age group, 18, does not fit, apparently does not fit in the Beckett program, if I heard the commissioner's testimony correctly. And the same is applicable to the Sununu facility in New Hampshire. And so that then becomes a concern for the judges who are sitting in this division as what resources are available for this age group, and in particular those that are 18 that come in with serious offenses. And I will tell you that we don't have an answer for that, but I can tell you that at least from the judges that I've heard from, and I believe at this point I've heard from most of the judges sitting in those dockets, that continues to be a concern, the lack of secure facilities. I understand from commissioner's comments and perhaps other testimony during the course of the session that they are working on that, but that certainly is an issue from the judges that are involved in these dockets on a day-to-day basis. The other issue that they brought up is, again, because of this age group, 18 in juvenile court, if they don't comply with restorative justice programs, if they are not successful on probation, there is not a lot of leverage if they are considered delinquencies. And so it's almost as if there's a gap sometimes. I think some of the judges referred to it. I can give you an example. When they're referred to diversion, this judge noted that the problem is when they don't complete diversion or don't appear, then what? If they're over 18, the motivation may not be there to comply with probation conditions and or diversion programs, and what is the ultimate consequence other than perhaps an unsatisfactory discharge. So I think, at least I hear from the judges that more programming would be helpful for this group. And I understand that the commissioner's office is working on that, and we talk about that in the juvenile justice stakeholder group as well. So those are some observations, at least from the judges that are handling these cases. Committee members may have other questions, and I will attempt to answer those as well. And at some point, I do have one comment on 107, if that is going to be taken up in the veto session. Just to,
Why don't you go directly to the S107 comment?
oh, I have testified, and I believe Pat Gable has as well, when 107 was before various committees. We did not see this as having any adverse impact on the court, and we did not otherwise take a position on the bill. I just note that the language in the bill speaks to when a person is subject to the jurisdiction of the criminal division of the Superior Court. It says the criminal division of the Superior Court shall become the sole records custodian. Under the Public Records Act and electronic records, it is the court administrator that becomes the records custodian. So as you're taking up that bill, I would ask the committee to change the language just to read that the court administrator shall become the sole records custodian.
So noted, and Hal, make a note of that, because it would be more in your bailiwick for that. Questions, Dick?
Yeah, I have a question, and it's from the 2019 report. And it deals with those non-Big 12 offenses who are incarcerated at the time. And the report concluded that there were very few kids who were in. There appear to be relatively few. I'm going to read from page 24 of the report. There appear to be relatively few 18 and 19-year-olds who are convicted of non-Big 12 cases and incarcerated at the Vermont Department of Corrections. Reviewing the point-in-time data shared by DOC for the first half of 2019 was a maximum of 12, 18, and 19-year-olds in DOC custody. Data include people in DOC custody both pre and post-conviction. And they may include youth whose cases involve Big 12 offenses. The intent, and my question, Judge, is can you find out for us how many kids that where the charges are Big 12 offenses, where they're dealing with those offenses in either youthful offender status or as raise the age, they're 18 under the new law starting July 1, 2020. I'm trying to figure out what is the number of kids who would require secure placement, and have some courts or some state's attorneys taken Big 12 offenses and allowed them to be tried as either youthful offender or as juveniles, which would increase the need for secure placement. But
exactly.
At the time that the report was done in 2019, it was not our intention. And, perhaps we need to rethink the allowing some Big 12 cases to be heard in juvenile court.
All right, so Senator, I just want to make sure I have the question right. You're looking for how many cases either in YO status or age 18 involve Big 12 offenses?
Yeah.
Okay.
Where the charge has been Big 12 and where the state attorneys are either prosecuting it or having it, I understand that at the time that we did the bill, there was a great deal of discussion about whether to allow certain Big 12 cases to be heard in the family court. And we went with that because we felt that there may be that one or two cases where it would be appropriate. But it sounds like there are a lot of them.
So I will track down that data. for
Because
you.
at the time, there were very few 18 and 19-year-olds in DOC custody that had not been charged or convicted of a Big 12 offense. And that was part of the reason, and I'm looking at Commissioner Brown now, because I think that was part of the reason that we didn't say, go establish an 18-year-old, 19-year-old Woodside. Because we felt that, there may be a need for some staff secure placement for some kids. And we understood that, but I'm just curious if that's part of the problem.
Yeah, and I'll try to track that information down, for that data down for you, Senator. Sometimes.
I mean, if judges are complaining that they don't have the resources.
Well, I think what I need to look further into is, the numbers are important, because all it takes is one very difficult case for a judge to say, well, we don't have the right setting or the right facility for this. And I think as the committee is considering this question, the numbers are important. Are we talking about a significant number? And I don't have that information for you today, or whether it's when these cases come along, they create problems not only for the judiciary, but for the commissioner's office as well as for placement. And so they tend to obviously get our attention when they happen. The real question, though, is how frequently are we confronted with this issue? And I'll try to track that data down for you.
Thank you.
So, Judge, when a judge is confronted with something like this, what is the result? Where does the offender, youthful offender, where do they go? They can't stay in the courtroom. So then what happens?
I don't know of specific cases, Representative Emmons. I can certainly look into that further for the committee, unless the commissioner has some immediate response to that. The difficulty is in finding a setting that may not be secure in the sense that we're using that term, that the parties feel comfortable in placing that individual.
So, Commissioner, could you weigh in on that? You can't just, if the courts feel that there needs to be a more secure setting for the person, what happens in that interim?
So, and I think it's a good question, Representative. I think we have to step back and just make sure we're not mixing the two different emerging adult populations that we're discussing, raise the age, which are 18-year-olds treated as a delinquent, versus up to 22-year-olds have been charged as an adult, who then can request youthful offender status, which removes them from the adult court system and puts them under the joint supervision with DCF and corrections. And many of the youthful offenders that are granted that status overall are minor, small offenses that don't require a great degree of secure placement. We have family or friends that can support that person, and we keep them on like a probation type status, and we work with them that way. I think what we're talking about here is when we have an 18-year-old that might have been charged as an adult. I think what we're seeing are they're not necessarily a level of dangerousness we are seeing some of those cases. We're seeing youthful offenders who are being referred that have a level of dangerousness that gives us concern, and that's one of our concerns. But with raise the age so far, given the exemption of Big 12, that they're not eligible for raise the age, and they're charged in the adult system. But what we're seeing are just the work we're doing now to establish some sort of supported housing, because there's a number of offenders, a smaller number of raise the agers who lack a natural support system of family or friends that they can rely on. And that's the work we're focusing on right now in developing these programs across the state, so that if someone does not have a place to go and they come into our system, that we have a supported model in place to support them with housing, connect them, make sure they're connected to services, whether it's economic services, mental health services, substance abuse services, or employment services. Those are all critical components to success for our emerging adults to be successful later on in life as well. And so that's the work we're doing right now. I would agree with the Judge Grierson, in terms of raise the age. It's a very small number where there might be a level of dangerousness, and I think that's what we're raising is it might not be a Big 12 charge, but that there's a level of dangerousness with this youth based on different factors that we know exist that might not make them appropriate for our system of care, just given that level of dangerousness. And that's the work we're doing right now with the Juvenile Justice Stakeholder Group, is to see if there's a better way we can assess risk and personal and public safety concerns to make sure youth are being served in the most appropriate setting, security-wise, kind of to the heart of your question.
I understand that, and it's going to take time to get those proper secure settings. It's what happens in that interim. And I'm not hearing an answer to that.
Yeah,
Does the person go to a correctional facility to be held?
No. If they're a delinquent, they're not in a correctional center. If they're treated as a delinquent, we don't put delinquents in the correctional center. The only time they would go to a correctional center if they've been charged with a Big 12 and are being held without bail as an adult. I don't think we've seen someone that needed a secure, to my knowledge, we've not seen a raise the age who we've needed to lock up in a secure facility. Because it's not that, that's not been the intent of this law. And so I don't think we've experienced that yet. We've certainly seen youth come in with high levels of need, whether it's mental health or substance abuse, and then we make sure we're connecting them and getting them connected to the right services.
Thank you. Any other questions of the judge before we move on? I'm open to whomever would like to go next. We have John Campbell. I know Marshall Paul is now visible. So Marshall, do you want to go next?
I'd love to, because I'd love to just start by sort of following up on the question that was just asked, specifically about how to deal with housing serious youthful offenders who have been charged with very serious, potentially Big 12 offenses. And I think one of the things that was missing from that conversation is that it's actually a fairly easy problem, because it's sort of self-regulating in that as an attorney, if I have a client and I'm trying to get my client youthful offender status, one of the big questions that the court is going to ask is, what kind of treatment does this kid need? Where is that kid going to receive this treatment? And they're not going to get youthful offender status if that treatment is not available. So if TCF comes in and says, this kid needs a residential level of care, they need intensive treatment, and that treatment is not available in a residential setting for someone who's over 18, then they don't get youthful offender status at all, and they stay in the adult system. And the same is true of kids whose behaviors escalate. So perhaps if a kid is granted youthful offender status because at the time everybody looks and says, oh, this kid is really compliant, they're doing well in treatment, they're going to do well as a youthful offender. But sometimes, you know, kids being kids, things go sideways and the kid starts to engage in very risky behavior that does require secure care. That behavior is certainly going to be, you know, any kind of behavior that would cause the department to say, wow, this kid needs to be, you know, housed residentially, perhaps in a secure setting. That behavior is going to be a probation violation. And if that kid's probation is violated, they can be detained in a DOC facility while their probation violation is pending. And if after their probation violation has been adjudicated, then the question is, what do you do with them? If a kid engages in a fairly minor probation violation, they might be given another shot. They might be given a chance to keep on receiving treatment. But if it's something major and if the resources are not there to address it, they're gonna be revoked and sent up to the adult system for sentencing, and they'll be housed in DOC, and there won't be an issue of placement. And that's really, you know, that's why it has not been a problem, is because it's a self-regulating system, because any behaviors that would require that kind of housing are behaviors that are either going to prevent you from getting youthful offender status, or they're going to result in your youthful offender status being revoked and being bounced up to the adult system and the DOC. And so then with regard to sort of the number of cases, you know, I'll be very curious. We haven't seen the statistics that Judge Grierson referred to. We'll be really curious to see those. But I think one of the things that's been, you know, like everyone else, we were surprised at the number of youthful offender petitions that were filed. When we made the change, we expected it to increase the number of YO petitions. We did not expect it to increase as dramatically as it did. But that said, the system has been very good, I think, at determining from those petitions that are filed which ones are appropriate to be granted and which ones aren't. And I think the proof of that is when you look at how rare it is right now for kids to be revoked. You know, that's when, you know, if you're looking at a youthful offender case, the proof is in the pudding. Kids either get revoked or they don't. When they don't, that's a sign of success. Those are kids who made it through treatment, made it through the process of being under supervision without committing any violations significant enough to warrant the court saying, you know what, you really need to be treated as an adult and treated by DOC and, you know, subject to a much longer period of supervision. It's when kids, you know, kids are revoked and they are sent up that we really should be looking at that as a failure. And really what it is there is it's a failure of identification. It's a case that probably shouldn't have been granted youthful offender status, but was granted youthful offender status. And what we've seen is, yeah, there's a lot of petitions being filed and there's a lot of petitions being granted. Certainly not all of them, but a lot of petitions are being granted. But we're seeing relatively few revocations, which to us is a sign that this system is working and it's working as it was intended to work. And the fact that we see so many cases coming in, more than we expected, we're actually seeing as that's a sign of success, not a sign of failure. It's a surprise, but it's a good surprise. We would think it was a bad surprise if we saw a huge number of cases coming in, a huge number of cases getting granted, and a large number of cases getting revoked. Then we'd be stepping back and saying, whoa, we're getting something wrong here. We have a lot of kids in this system, and a lot of them are kids that don't belong in this system. But as long as those kids are coming in and we're properly identifying who's going to be successful as a YO and who isn't, then we're doing well. So to us, the YO program looks like a success, and we'll be interested as statistics come in to start really looking, you know, and sort of pulling them apart and digging deeper and seeing, you know, among those kids that get revoked, are there similarities among them that we can use to even further refine the criteria that we apply when we're doing youthful offender consideration hearings, so that we can be even more accurate than we already are in our determinations of who's going to be a successful youthful offender candidate, because it doesn't serve kids well to be inappropriately granted youthful offender status. In fact, you know, the way we train all of our attorneys is youthful offender status is it's a great option for kids who are going to be good supervisees, and it is a terrible option for kids who are not going to be good supervisees, because it's a worse outcome to be a youthful offender and have your youthful offender status revoked and be sent up to the adult court for sentencing than it is to just resolve the case in the adult court in the first place. Because when you resolve the case in the adult court, close to 97% of our cases are resolved through some sort of a settlement or dismissal, not through a trial. And what that means is that in the vast majority of cases, almost all cases, people's sentencing exposure is limited by a plea deal. You work with the prosecutor and you agree that this is you agree upon a particular sentence, or you agree upon a sentencing range. You agree we'll have a contested sentencing, but the prosecutor will be capped at asking for this, and the defense will be capped at asking for this. So we're just arguing about a range here. But when you are revoked as a youthful offender, you're sent up for an open sentencing, meaning the judge can impose any sentence from the minimum that's in the statute to the maximum that's in the statute. And so really that's a horrible situation for a defendant to be in. It's as if they walked into court on the day of their arraignment and pled guilty and just submitted to the sentencing of the court. And that's exactly what attorneys try to avoid. That's the situation that attorneys try to avoid putting their clients in all the time. I mean, that's if we weren't trying to avoid that situation, there would basically be no need for defense attorneys. I mean, a defense attorney's job is to limit your client's exposure to sentencing. And so it's considered a real failure when a kid gets revoked. And we would not be looking at, cases. We don't see it as a success when a kid who is really, a marginal case who really shouldn't be granted youthful offender status because they're not going to be a good supervisee. We don't see it as a success when a kid like that gets youthful offender status, because it really doesn't serve the kid well. They are very likely to get revoked. And in being revoked, they're very likely to be put in a situation that's worse than if they had just stayed in criminal court in the first place. So while the numbers are large, and those large numbers are surprising, from our point of view, it works exactly as it was intended to work. And it's really been successful. And youthful offender, in comparison to the raise the age population that we've been talking about also, we even have more years of data to work with there, because that change was made in 2018. Whereas for raise the age, frankly, we've talked about it in our office, and we look at it and say it's really too early to have any conclusions about raise the age, because it was implemented less than a year ago. And if there's any year that you shouldn't look at as being any sort of an indication of how things are working, it's been this past year. And some of the things that have been talked about, especially around the availability of programming for kids, the availability of residential programs for these kids. These aren't just problems in Vermont. These are problems everywhere. They've been exacerbated by the pandemic. I just spent 3 days last week in a big 3-day Zoom meeting with juvenile defense attorneys from all over the country. We had people from Utah. We had people from Nebraska. We had people all over. I mean, I think there was 30 states represented. And we spent so long talking about the problems of residential programming during the pandemic all around the country. All over the country, programs have been shutting down. They've been stopping admissions. Some of the ones that have not stopped admissions have really limited which kids are going to be allowed in and which aren't. So even when admissions aren't fully stopped, they are at least partially stopped at the highest ends of the level of care. Even though the high-end providers of secure placements, providers of intensive inpatient mental health services, even though a lot of those guys are still accepting admissions, their programs are full because those programs almost always, they don't result in a discharge home. They result in a step down to a program that's less secure. And most of those programs stopped accepting admissions during the pandemic. They kept the populations they had, but they didn't accept anybody from outside coming into their bubble. And so it's been a problem all around the country. Vermont has not at all been immune to it. And frankly, because of the small number, our small population and the fact that we rely on some out-of-state placements, which makes sense. I mean, I think there's always a lot of criticism of out-of-state placements that is sometimes warranted, but sometimes not. Some out-of-state placements are really great, really specialized, and provide care that we could never provide in state. And so we're more dependent on out-of-state placements than larger states might be. And so we may have been impacted even more than some states that have more control over their system of care. But the fact is, yes, it's a problem, but it's not a uniquely Vermont problem. It's something that people are dealing with all over the country, and we're right along with them.
So thank you, Marshall. I do want to move this along because we're due for a break, and we do have some folks scheduled at 11:15 for Justice Reinvestment 2. Are there any questions of Marshall before I turn it over to the state's attorney's end?
Good morning, Madam Chair and committee. Thank you for having us. I know you're very short of time, and I know how these things go. So I'm just going to talk very briefly on the 107 on the veto.
Would you just introduce yourself for the record, John?
John Campbell, for the Executive Director for the State's Attorneys and Sheriffs. And then I'll turn it over to Evan Meaden, who will talk about the raise the age and the YO issue. One thing, though, before I go to the 107, I really believe what Marshall had said was about the revocation, that there have been few revocations. I want you all to understand, though, that the question is, when do these revocations happen, and how many times does somebody have to violate before they're revocated? And I would urge you to bring DOC in and talk to them about that and ask them, how many incidents occur before anyone does in fact get revocated. As far as 107 is concerned, as you know, clearly the governor's message, there's two issues. One has to do with the confidentiality of the records and the records custodian, and when the juvenile records become confidential. That issue there is, while I really appreciate the committee trying to take care of that and address it, it still doesn't address a big problem, and that is the inconsistency throughout the statutory framework of when a juvenile record is confidential, what records are we talking about? And even if we did have the court administrator as the custodian of the records, which records do we send? Are records of that involve work product from our offices, are they supposed to be going over there as well? So I think there are other issues that really need to be looked at with that. And I think that there's an opportunity here to really bring the public records law into provide consistency with it across the board, because we have found several issues and several problems, especially dealing with confidentiality of juvenile records, of when they can be released and when they can't. The second part, which was what Senator Sears and you all have identified, and that is the governor evidently obviously is concerned about the raise the age. And I just have to go back again, something Marshall just said, is that this was, and I think all of us in the system were supportive and trying to get this thing to work and to move it along. And nobody could have predicted what happened last year, with the pandemic. And as much as I know that we're dealing with a severe lack of resources in the state that can help address some of the problems that might arise from raise the age or the YO, we basically, everything was ground to a halt. So even the numbers that we're talking about here and the percentages, I'm not sure if those are going to give you an accurate picture of what the success or success of what this program will be, or this policy change will be. I think it's got a great deal opportunity for success, but I think we have to continue to try to build on that foundation, and then to, especially with the resource side of this, to make sure that we do have availability of places for residential treatment for residential for secured residences. And the question that I would have would be is, and I think you asked it, Madam Chair, is how many 18 and 19-year-olds are currently out on the streets that are not, there's no place to place them. And, you know, that problem's not gonna get any better because we know Beckett now is gonna be an issue there. And if you talk about Sununu, which they don't take them, and even if they, even the ones they do take, we still have to have hearings to under the compact. I just think that there's so many other questions that need to be answered, and or the questions that need to be asked. And we need to, as a state, decide we're going to, you know, put everything we can behind this policy, which I think it's been a sound policy, and I think given the right circumstances, we would be able to make it work. With that, Madam Chair, I will turn it over to Evan and ask him to give you a briefing on the remainder of our testimony.
Okay, before you go there, I saw Senator Sears' hand up. So Dick?
Well, I wasn't going to let Executive Director Campbell get away without at least a question. I appreciate your comments about the public records. We generally in judiciary have not dealt with public records issues, and maybe it's something that we should deal with, but it seemed to me that was a government operations issue. But in terms of the secure placement, at the time we were doing the raise the age, and at the time that we were looking at that, there were very few kids 18 years old or 19 who were incarcerated for non-Big 12 offenses. And additionally, there were very few youthful offender petitions for those who had committed or been charged with Big 12 offenses. As you look at throughout the state, there's a difference in state's attorneys. Have you or will you have recommendations for any changes from the State's Attorneys Association? Because as I understand it, there's a few cases that came out of one county where, you know, it did concern many folks in terms of, I think it was a youthful offender case.
So I'm glad you asked that, because as you know, you and I go back and forth. We talk about this a lot, about the 14 forms of justice. And again, I have to remind you is that it's not just the state's attorney involved. We have the defense attorney who represents the individual. You have the judge. I mean, the judge is probably that's the person who makes final decisions. That's the person that if the petition for YO status is put there before, it's the judge who makes the decision whether that actually occurs and whether that person goes into it or whether they don't. And I can tell you, there is geographically, there's a lot of differences in the judiciary. There are certain counties where there are judges that are considered to be more liberal than others, or that take a different stance on let's say the revocation of probation. They might say, well, we're going to give them another chance, or another chance. We can't control that. That's all in their hands. So as much as everybody would like to point out and say that we have all this ultimate power, I challenge that. I don't think that is accurate. So, but I can tell you now another part, because I know where you're going with this. Yes, we have met, and I think if you've seen what has happened with our state's attorneys over the past few years, especially with our with diversion and with alternate forms of justice for individuals, we've been doing everything I think that the legislature has asked us to, especially during the pandemic. We worked very closely with the defense bar and with DOC to get people out of incarceration that could be housed in outside. So, I mean, I think we're moving there and we're trying our best, but as you know, we are also hampered with with the fact of lack of personnel, which thankfully this year, you all have addressed, and we'll be able to fill those positions. And I think that will give us more time to work with individuals who come into the system to find.
I appreciate that, John, and I really do. What always scares me in this work is that we're always one really bad case away from throwing the baby out with the bathwater. And in these cases, we've obviously heard about one particular case in Chittenden County of a person involved in a mall shooting. It worries me. So that's why I'm asking if there's legislation that you're all contemplating regarding improvements to raise the age in youthful offender status.
I think there are suggestions we're going to have because some of the issues that were just brought up. Let's just take, for instance, the people using youth to commit crimes, whether it be drugs or weapons or breaking in to homes. That's nothing new. That's been going on for eons. That's
a form of human trafficking.
Exactly. And I can also say is that unfortunately crime has not stopped. There are so many more things happening right now that the law enforcement, if you look at the state police, they're down 63 spots. I get calls repeatedly, almost on a weekly basis, at least 2 or 3, from citizens saying, why can't something be done? I have drug dealing. It is so clear. There are multiple cars. They're from out of state. They're sitting, these people come over. I mean, these are from all around the state, including one I heard from up in Chittenden County where a person's been taking video and it's going on right next to a school. We are, I think, going to be facing, when everything starts opening up again, unless we are able to put all of those, get all our resources back up to where they were, we're not going to be able to actually, it's not the enforcement, it's just actually the identification of criminal actions and activity and using their kids or, again, human trafficking.
Well, I'm glad that we put 16 million in ARPA money into the criminal justice system to help you recover from COVID.
So am I. And I think there's a lot of victims out there because, again, we cannot forget that when there's a crime, there's also some victims. And some of the victims are the individuals who commit the crimes themselves when it comes to these, drug overdoses and things of that nature.
Well, one thing I think both Representative Emmons and I and the members of this committee would appreciate is any suggestions for legislative change that we can get them as early as possible and have them discussed in this committee.
And I think Evan might be able to talk a little bit about some of that.
So let's transition to Evan. Evan, welcome. And if you could identify yourself for the record.
Absolutely. My name is Evan Meenan, and I am a Deputy State's Attorney in the Executive Director's Office of the Department of State's Attorneys and Sheriffs. So one of the things that we did in light of the veto message and prior to testifying today was reach out to the state's attorney's offices to get their thoughts and perspectives on what has and has not been working with the Raise the Age law. Before I get into summarizing their feedback, I do want to flag that occasionally these conversations can be a little bit difficult because sometimes the effects of any individual law are best reflected by specific cases. However, the confidentiality provisions related to juvenile proceedings sometimes prevents us from getting too far into the weeds. So I'm going to do my best to summarize things from a general perspective in order to respect those confidentiality proceedings. None of the feedback that I received indicated that the state's attorneys had objections in principle to Raise the Age law. However, they did have some concerns, which I think the testimony of Commissioner Brown and Judge Grierson also highlighted. It appears as though there are many, many instances of 18 and 19-year-olds successfully navigating the juvenile justice system. And we're not going to allege that most folks are not being successful. For example, in one county that we heard from, there were 3 youthful offenders that were sent to diversion, and they all successfully completed the diversion program. In that same county, there was 10 delinquency petitions that were referred to diversion, and all 10 of those juveniles also successfully completed the diversion program. So those are some success stories with the diversion programming itself and people being able to navigate that system. However, even in that group of cases, there's some specific instances of subsequent behavior that has caused some states' attorneys to question whether or not the risk assessments that are being applied to this particular population are sufficient. And I think that's one of the things that Commissioner Brown testified to. And I can give you just a couple of examples. For example, amongst those 13 folks, one of the youthful offenders subsequently committed another DUI after completing diversion, and another one committed 2 additional DUIs. Now, I'm not going to argue that a DUI is the crime of the century, and we know that folks can continue to struggle with that particular offense, and it's not uncommon to see subsequent DUIs even after someone's case is handled in the adult court system. However, there are some more concerning cases that have led to questions about the risk assessments. For example, one of those juveniles who successfully completed diversion subsequently committed over 50 thefts after completing the diversion program. And he was also subsequently charged with committing 2 sexual assaults. Now, granted, the sexual assaults were committed before he went to the diversion programming, but they were reported and he was charged after the fact. And so there's some question as to why, whatever characteristics might have led to that risky behavior were not picked up in the risk assessments. Another concern that was expressed aside from that with risk assessments had to do with how the confidentiality of these proceedings can play out. It doesn't just occasionally limit our ability to discuss things in depth, but it can sometimes have real impacts on the victims of these juvenile offenders. And I can give you one particular example. We are handling a case right now where there was one juvenile who is alleged to have committed a sexual assault against another juvenile. Now, that particular individual's case was transferred to the family division. And what happened subsequent to that was a little surprising. That juvenile apparently, according to the state's attorney, has been representing in the school and in the community that his case was dismissed or that the charges were dropped, when in fact there is still pending a court case against him. That has created quite a bit of heartache for the victim of the offense, because what it has done is it's created another credibility contest amongst an alleged offender and alleged victim in the community. And the state's attorney's office has a very limited ability to dispute publicly and in the community that in fact there is still a case. The charges were not dropped, they were not dismissed by the court, and this is still pending. And so I give these anecdotal case examples as a way of highlighting some of the things that Judge Grierson and Commissioner Brown were also mentioning. Risk assessments, some more exploratory work needs to be done around those, especially in detecting an individual's level of dangerousness. And in order for the Raise the Age law to be effectively implemented, in other words, it adequately addresses recidivism and it protects the public, comprehensive services need to be in place. That includes making sure that DCF workers have the adequate support they need in order to address any increased caseloads or the increased complexity of some of these cases. It means that there needs to be opportunities for residential rehabilitative services, and there needs to be facilities where these individuals can be comfortably housed. Now, the department does not itself provide many of those services that we're hearing anecdotally might need to be bolstered. And for that reason, I think the value that the state's attorney's input can provide is to flag how this is affecting specific cases and specific individuals, both alleged offenders and alleged victims, and to encourage not only this committee, but others involved in the justice system to really hear directly from the people that are providing these services, whether it's DOC, DCF, or the community providers themselves to say, this is the scope of what we can do comfortably. This is the scope of what we can't do comfortably. And if you would like us to do more, here is what we would need. In terms of Senator Sears' question about whether we would have particular legislative proposals, I did not receive any feedback from state's attorneys on specific changes, but that is absolutely a conversation that we can have in-house in order to try and figure out, are there actually any legislative changes that need to be made in order to address some of these service deficiencies and confidentiality problems? Or can this be addressed through work within individual agencies, including the state's attorney's office, Defender General's office, and the Department of Corrections and DCF?
Thank you, Evan. That was very helpful testimony. Thank you. Any questions? We are running over a little, so I'd like to finish up with David Shearer and then take a quick break for that. So David, welcome. If you could just
thank you, Madam Chair, and thank you to the committee.
For the record.
Yes, David Chair with the Attorney General's Office, Assistant Attorney General and Co-Chief of the Community Justice Division. I'd actually like to just take a minute to address S-107 itself and then move on to a couple comments about where the Attorney General's Office intersects with the raise the age issue, and hopefully I'll do this all fairly quickly. With respect to S-107, Senator Sears already referenced the veto message of the governor, which was a little bit surprising because the message itself had almost nothing at all to do with the substance of S-107, and only one sentence in the entire message actually gestured towards the substance of S-107. So I did just want to note what S-107 was doing. It was a modest bill in many ways, and I'd even call it a technical bill, but it is, I should say, an important bill in that it made consistent across the entire life of the case the long-standing policy decision that young people who end up in juvenile court get the advantages of confidentiality. And I think, and this is a decades-old policy decision. This is nothing new. And I think that the reasons for that are broadly understood. Young people have maturing brains, can act more impulsively than older folks. And so when they make mistakes, we give them a chance to correct that harm and rehabilitate themselves in a confidential manner, and so that they don't have criminal records that could follow them for the rest of their lives and create a substantial burden on them when they begin adulthood. All that S-107 was doing was saying, hey, at the very beginning of this case, we identify this gap where folks who could end up or who do end up in juvenile court, that information may become public, and it defeats that very long-standing policy decision. And so we're just trying to close that gap and make sure that this decision around giving young people this advantage, this ability to enter adulthood without the burden of a record, will in fact be real in all cases. Of course, there are cases where young people, juveniles, will end up in criminal court, and those will all be public under the rules of criminal court. And so the choice to use this bill as I should say the veto of this bill as a mechanism to raise a largely unrelated issue. And I should say that, sure, the raise the age has extended the advantage of confidentiality to people who are 18 and soon to 19. But the confidentiality that goes with that policy decision was made back in 2018 when the legislature passed and the governor signed the bill, Act 201, to allow for that. So again, this isn't a new, S-107 doesn't repeal that, it doesn't change that. All it does is make consistent this longstanding policy. For most cases, for decades, for older folks since 2018, that people will retain the advantage of that, and there won't be this gap in that policy. And the choice to use the veto message on that bill to talk about what is really a different issue, I think will have costs, and those costs will be borne by some young people in Vermont who may lose the ability to start their adult lives with a clean slate and a fair shot at success. So I want to turn to, and so that I do think, this conversation of necessity has been about raise the age, but I did want to address S-107 because I think it was an important bill, even if it was a rather modest bill. and ensuring that advantage and ensuring that decades-old policy decision is made real in as many cases as is possible. Turning to the AGO's intersection with Raise the Age, the place where we intersect most is with our diversion programs, which were really relied on in the creation of this to take on some of the cases that will now be funneled through family court. It's important to note that diversion was already dealing with a pretty large percentage of 18-year-olds. I'm going to confine this to 18-year-olds because that's where we are right now in the Raise the Age process. Although I should say the 19-year-old data is very similar. For 18-year-olds, diversion was already dealing with a lot of the cases that were coming through criminal court. About a third of the 18-year-olds charged typically were going to diversion. And I should say, because Raise the Age happened in the middle of 2020 when all statistics are completely skewed, we don't really have good information about whether or not there are sort of different types of cases, different complexity of cases, significantly increased burden. We just don't know because all the numbers are down considerably because of the slowdown in the court processes. And so it's really hard for us, I should say it's impossible to tell. I did do a little back of the envelope calculations on fiscal year 2019. In fiscal year 2019, I looked at obviously, as I said, a big percentage of cases were already going to diversion. Another chunk of cases that was being adjudicated was ending in fine-only resolutions. As a mechanism to try to figure out what this might mean, if all those fine-only resolutions and fines are not available in family court as a resolution. So let's suppose that all of those were to instead be diverted and go to diversion. Looking at the numbers from 2019, that would add to diversion's total caseload by about maybe a little less than 3%. So we're really not, in terms of the overall diversion caseload statewide, so we're not looking at something that is going to significantly increase the burden on diversion. When this bill was signed, those are numbers that we looked at, and we believed that we could certainly absorb that, and we still believe that, assuming that trends return to normal in the next couple of years. So that's the number one place where our department interacts with this, and we certainly strongly support it, and we do think that the numbers bear out that we can absorb that. And I should say our criminal division very rarely deals with cases where there is an intersection where people would even be eligible for either youthful offender or juvenile delinquency jurisdiction. So that's not really much of a factor for us. And I did want to note there are individual cases certainly in diversion that can raise concerns, but I think it is important to note that the Crime Research Group did a study for those who are referred to diversion as first-time offenders. The likelihood to reoffend is 8 times less likely than similarly situated people who go through the regular criminal division. So there are dramatic advantages to public safety to sending people through diversion, especially for those first-time offenders. And we do expect that many of the 18-year-olds will fit into that category. And I think the data bears out that many of the 18-year-olds fit into that category. So tried to give it my testimony quickly. I know we're running out of time, but happy to answer questions if there are any.
Thank you, David. Questions for folks? I don't see any. So that wraps up this portion. I hope this has helped the committee understand the difference between S-107 and Raise the Age, that they're not connected per se. And will give us some more information when we get closer to our veto session in a couple of weeks for that. And Hal, thank you for joining us. I hope this has been helpful to you as well.
Most helpful. Thank you.
Great, thank you. So